Yes, what are the further submissions?
Yes. But last time I had said that the ground that these are essentially civil proceedings.
Yeah,
And Lord, I said that
spend time on that.
मेरे पास नहीं.
Spend time on whether it is civil nature or criminal nature. Real argument should be 482 will apply because it's a proceeding before the court. Now, what should be the scope of interference?
I will make my submissions on that, but on the first point, your lordships need to pronounce on this.
It's not necessary.
No, because
I will tell you why. It is before a criminal court of magistrate. We are not going to enter into an area where relief under this act is claimed under in civil proceedings. We are not going to enter into that arena at all. So therefore, we have to concentrate on one fact. The test which is applied for questioning criminal proceedings, the same test should be applied in case of section 12.
That's altogether different thing.
That's the main issue. We are with you on the point that 482 will apply.
I know, I have seen that, Lord. My submission is
that we not spend time on irrelevant things, whether it's civil or criminal, that is irrelevant.
No, therefore, I'm not on that. I'm not on that.
Correct.
Since there are conflicting judgments of diverse high courts on this point, Lord, as I said, Madras High Court full bench has taken a view that the 482 is not available. Bombay High Court, Lord, there has been recently,
we'll go by that. Let him show that 482 will not apply.
No, Lord, your lordships may have to pronounce that because that's since there are conflicting judgments. No. I will not take much time.
See, it is so simple that it is section 12 complaint is maintainable for a court as defined under the CRPC. So therefore, whether it is civil nature, criminal nature, that is irrelevant. We are not going to that question at all. We are really on what should be the scope of interference considering the nature of this legislation.
Yes.
Whether at the drop of the hat we can allow interference to be made with section 12 complaint.
I fully agree that the social welfare legislation
having regard to the object of the DBS.
That act specially meant for the protection of women. Yes, my lord. That, my lord, cannot be diluted or cannot be defeated as a result of very casual or not so serious thought given to my lord before invoking
because for example, bashing FIR is concerned. Bajanlal and all, the law is very well settled.
Yes.
Very well settled. But in case of section 12, what should it is? Because after subject to hearing, of course, after holding that 482 will apply, we don't want to create a situation where at the top of the hat interference is made.
Lord, since your lordship said that subject to hearing other side, may I take about 15 minutes to at least substantiate why 482, my lord, apart from the
court?
Yes,
yes.
Lord, my submission is that this is whether it is civil nature of proceeding or not relevant because please see, my lord, the chart which I have prepared in my written submission.
Yes.
Page 6 gives the chart of diverse provisions of the CRPC, where, my lord, the relief of the nature which is granted by the civil court are available under the CRPC. Page 6, 7, 8 is the chart, and there are about 17 or 18 provisions.
Yes.
This is the chart. I will not bother your lordships by reading each and every item of that. Next page, page 8 and 9, I have, my lord, given in the table the provisions under the CPC, where, my lord, the relief which is granted by the court, civil court, is, my lord, in the nature of the orders passed by the criminal court. So, my lord, whether the proceeding or the relief granted by the court is of civil nature or not is not really a decisive test one. But one important aspect on which Madras High Court has proceeded is
CRPC.
proceeds on the basis of section 28 of the Domestic Violence Act. Lord,
Yes,
please,
Domestic Violence Act also.
please see the
What is that?
section 28.
Procedure.
Yes, my lord.
Yes.
May I read, my lord? Save as otherwise provided in this act, all proceedings under sections 12, 18, 19, 20, 21, 22 and offences under section 31 shall be governed by, my lord, please mark this word, shall be governed by the provisions of the CRPC.
Right.
And 2, nothing in subsection 1 shall prevent the court from laying down its own procedure for disposal of an application under section 12 or under subsection 23(2). My lord, what Madras High Court?
Just get correct. Okay.
Madras High Court relies upon the language used, shall be governed by. And what it says is that it doesn't say that the provisions of CRPC shall be applicable to. And how the term shall be governed by is different from shall be applicable to, how it is narrow. Some precedents are referred to. In the process, my lord, what the error which is committed by the Madras High Court is, please have a look at section 5 of the CRPC. Completely missed. Section 5 of CRPC.
Yes.
Nothing contained in this code shall, in the absence of a specific provision to the contrary, affect any special or local law for the time being in force, or any special jurisdiction or power conferred, or any special form of procedure prescribed by any other law for the time being in force. So CRPC itself contemplates that under special law there may be a special procedure. So whether CRPC procedure is applicable or not, to what extent it is applicable, whether the applicable to and governed by, what difference does it make, is completely insignificant according to me. This is the error which is committed by the Madras High Court. Now, my lord, my submission is based on 2 important things. And my lord, test according to me is one your lordship already referred to, which is the court on which the power is conferred under the DV Act. There are 2 more important tests, and those tests are: is the machinery of police available directly or indirectly for the enforcement of the provisions of the DV
No, there is
Act?
one more point.
Yes.
For example, 125 CRPC.
Yes.
Correct. Actually, if you see, it's purely civil.
Purely civil.
Now, if we take a view that 482 will not apply, even 397 will not apply.
Precisely. 397 will not
apply.
Yes.
482 will not apply.
482 will not apply. So same is placed with 145. So, my lord, whether police machinery is made available under the Act directly or indirectly, and my lord, I will show the provisions under which it is made applicable. And another test is if the coercive machinery under the CRPC is available under the DV Act.
And that last time we have shown.
May I just point out those provisions, my lord? My submission is that the provisions of the CRPC, my lord, procedure provisions of CRPC and machinery of police are intertwined in the DV Act. And my lord, I will substantiate that. Just have a look at, my lord, please have a look at the DV Act, my lord. Lord, I have already shown on the last occasion section 2G and section 3, where domestic violence is defined. Domestic violence is actually the criminal offense, my lord. A, B, C, D, all references are to the criminal offenses. Now, my lord, please have a look at proviso to section 5.
Yes.
Duties of police officers, service providers, and magistrates. Police officer, protection officer, service provider, or magistrate who has received a complaint of domestic violence or is otherwise present at the place of an incident of domestic violence, or when the incident of domestic violence is reported to him, shall inform the aggrieved person about her rights, etc. Lord, last proviso, Lord, at the end of that rule, provided that nothing in this act shall be construed in any manner as to relieve a police officer from his duty to proceed in accordance with law upon receipt of information as to the commission of cognizable offence. I have already shown domestic violence, Lord, ABCD. They are actually the acts, Lord, defined under ABCDR, which are criminal offences. And Lord, proviso specifically authorizes the police officer to again lodge FIR, etc., etc. So, Lord, they are actually going side by side. Simultaneously, Lord, same provision, allows that.
Yes.
Then below section 19, 4 and 5, etc. 19. I will read clause 1 first and then come to the 4 and 5. Now, clause 1 first part. While disposing of an application under subsection 1 of section 12, magistrate may, on being satisfied that domestic violence has taken place. Well, this is the requirement even under section 12, under section 18, etc. So, satisfaction and domestic violence has taken place, which is, as I showed, Milord, is an offense. Now, please have a look at subsection 4, 5, and 7. An order under subsection 3 shall be deemed to be an order under chapter 8 of the CRPC and shall be dealt with accordingly. Lord, what is this chapter 8? Please have a look at for that, Lord, at CRPC provisions.
Yes, security bond, etc.
Security bonds, etc. And in that, Lord, it's punishable if, Lord, there is something, Lord, some violation thereof.
See, the residence order
in default of security.
No, residence order is taken on par with orders passed under chapter 8.
Chapter 8.
Residence order, so that those orders could be enforced.
And one of the ways in which it can be enforced is imprisonment in default of security. So that is something available under this. Then please see clause 5, subsection 5. While passing an order under subsection 1 of subsection 2 or subsection 3, the court may also pass an order directing the officer in charge of the nearest police station to provide protection to the aggrieved person or to assist her or the person making an application on her behalf in the implementation of the order. So for implementation, police machinery is made available. And then clause 7. Magistrate may direct the officer in charge of the police station in whose jurisdiction the magistrate has been approached to assist in the implementation of the protection order. As I said, the police machinery and implementation of DB Act are not intertwined. And as such, there is always a possibility of some kind of abuse of the power by the police officer. In that case, 482 is something which is bound to be available under the law. Then next provision is section 27. 27 I already.
Yes.
That is about the jurisdiction. But what is relevant is section 30.
That protection officers
shall be public servants. The moment you make them public servants, the IPC chapter is attracted, and those provisions relating to offences against the public servants immediately are attracted. So, as I said, the powers of the police, machinery of the police, and the DV Act, they will not go hand in hand. Then, rule 5, rule 4.
So, rules under Domestic Violence Act. The part of your compilations.
Lord, your lordship may. Don't know whether. Milord, in fact, requisition was given. My learned friend is saying that rule 4, Milord. Milord, I am on a very limited aspect but very important aspect of this provision. Any person, just mark this, any person. Any person who has reason to believe that an act of domestic violence has been or is being or is likely to be committed may give information about it to the protection officer. Milord, one of the cardinal principles of criminal law is any person can set the law in motion. That is what is, Milord, actually contemplated under rule 4. And subclause 2. In case the information given to the protection officer under subsection 1 orally, he or she shall cause it to be reduced in, please mark this, shall cause it to be reduced in writing and shall ensure that the same is signed by the person giving such information, and in case the information is not informant is not in a position to furnish written information, the protection officer shall satisfy and keep a record of the identity of the person giving. So, akin to the registration of FIR.
No, it's not akin to a register FIR.
No, in the sense,
FIR has drastic
I know
consequences.
it's a drastic. I know, but the procedure, the process which is adopted for that. But first part is more important. Then subsection rule 5, domestic incident reports. Upon receipt of a complaint of domestic violence, the protection officer shall prepare a domestic incident report in form 1 and shall submit the same to the magistrate, forward copies thereof to the police officer in charge of the police station within the local limits of jurisdiction of which the domestic violence alleged to have been committed has taken place, and to the service provider. So, my lord, what is the object of this? Because proviso under clause 5, section 5 specifically provides that police officer may actually proceed with. This is something therefore relevant. Please have a look at rule 5, 6.5. Application to the magistrate. I will straight away read subclause 5.
Let me, as if it is application under section 125 of CRPC.
So, my lord, 125 on par with 125. 125 forgets to apply.
See, the most crucial point is this. If it is to be treated as application under section 125, if somebody challenges order issuing notice, so is notice not processed under section 12. Now, whether court should interfere at that stage, because
that's a different thing.
No, that's the main point we have to decide.
I fully see.
The reason is when process is issued on a complaint, different yardsticks will apply because complainant has to be examined, his witness has to be examined, court has to record satisfaction that the case to proceed is made out.
I fully agree that, my lord.
So, what we want to emphasize is this, that interference with your order issuing notice on section 12, that should be normally avoided. Otherwise, by that logic, notice issued on 125.
Court should be extraordinarily slow.
Exactly.
In entertaining
That's the crux of the matter.
Yes.
That's the crux of the matter.
Yes, Lord, I fully agree. Then my lord, rule 8 into bracket 13. Duties and functions of the protection officer. I will straight away read 13. To liaise between the aggrieved person or persons, police and service. So, my lord, police is brought in the whole process. My second test, which my lord I said should be applied, is whether machinery of police is somehow brought in.
Need not go thus far. It's very clear. If 42 talks about code.
I fully. In fact, that was one of my main arguments.
That's the crux of the matter.
Yes.
Scope of interference is another matter. Because when court interferes with the process issue,
Yes.
or FIR register, when criminal law is setting motion, it has very drastic consequences. Therefore, the approach of the court under 482 will be different.
I fully see.
Right.
Now, Lord, please have a look at rule 12, clauses 2 into bracket C and D. Means of service of notice. I will straight away read C and D. For serving the notices under section 13 or any other provisions of that, the provisions of order 5 CPC or the provisions of chapter 6 of the CRPC. Chapter 6, my lord, brings in, my lord, attachment, etc. Section 83, etc. That is again, my lord, a coercive nature of power conferred under the CRPC made available to the magistrate under the DV Act. Same is the provision with, my lord, clause D.
Yes,
so, there is one provision which has been analyzed by the courts while taking a view against 482, and in my view, actually, that is the provision which supports the contention that 482 is applicable, and that is section 31. Please have a look at section 31. I will read section. I will tell my lords what is the view taken by the courts against, and then will not make my submission. A breach of protection order or of an interim protection order by the respondent shall be an offence under this act and shall be punishable with imprisonment of either description for a term which may extend to 1 year, or with fine which may extend to 20,000 rupees, or with both. The offence under subsection 1 shall, as far as practicable, be tried by the magistrate who has passed the order, the breach of which has been alleged to have been caused by the accused. While framing charges under subsection 1, the magistrate may also frame charges under section 498A of the IPC or any other provisions of that code or dowry prohibition act, as the case may be, if the the facts disclose the commission of an offence under those provisions. What the courts say is that it is only under section 31 that an offence is prescribed, and therefore only for the purpose of 31, 482 will be applied. Well, my submission is the change which is brought in by section 31 is orders, though of civil nature, are not executable before the civil court. The threat and coercive, my lord, power of the conviction and punishment under the criminal laws is brought in, my lord, under section 31. So, my lord, the orders of civil nature, though, my lord, they are not executable in the ordinary way in which decrees or orders of the court, civil courts are enforced.
No, all that will be relevant where court is dealing with exercise of powers and DV Act by a regular civil court. And in that case, court will have to hold.
Perhaps section 26.
26 is resorted to in civil proceedings.
Yes, in civil proceedings, then will not.
In such a case, if there is prosecution 31, still 482 will apply.
Yes.
That's the. Therefore, we are not dealing with that contingency at all. What happens to
that contingency may arise only if section 26 is
that's
invoked and civil court is authorized, my lord, yes.
We need not go into that controversy at all.
So, my lord, if looking to, my lord, provisions of the DV Act and the rules as a whole, it is clear that, my lord, 482, my lord, is and 482. Please have a look at 482 as also 483.
Yes. मेरे पास आर्टिकल
My lord, 561A under the old code, consistent view of the courts in India is that, my lord, it only recognizes what the courts already had.
Because it's inherent power.
Yes, inherent power. Nothing in this code shall be deemed to limit or affect the inherent powers of the High Court to make such orders as may be necessary. My lord, there are three components to give effect to any order under this code. So, my lord, insofar as code is concerned, first component, my lord, is directly, my lord, referable to code. But the other two components of 482 are not referable to code. And second is directly referable to the court to prevent abuse of the process of any court or otherwise secure the ends of justice. Because these last two components have nothing to do with the court. If there is a court which is, my lord, assigned the powers under some other special act.
Because after any order under the court, there is a comma.
Yes.
Then there is or to prevent abuse of process of court or otherwise to secure ends of justice.
And, my lord, if 482 is read in the manner in which the other courts have read it, please have a look at section 482. 483, I'm sorry.
83.
Duty of the court, High Court. Duty of the High Court to exercise continuous superintendence over courts of judicial magistrate. Every High Court shall exercise its superintendence over the courts of judicial magistrates subordinate to it as to ensure that there is an experience. So, my lord, all courts subordinate to it are made amenable to the jurisdiction of the High Court under 483 for this purpose, limited purpose. But, my lord, what we say that once the court constituted under the CRPC is assigned, my lord, the powers under DV Act, my lord, that will be amenable under 482. Now, my lord, one more aspect of DV Act. Please have a look at section 29. 29 of the DV Act. Appeal. There shall lie an appeal to the Court of Session within 30 days from the date on which the order made by the magistrate is served on the aggrieved person or respondent, as the case may be, whichever is later. But there are two aspects of it. For that, please have a look at section 482 of the CRPC. 472. 372.
That's the appeal.
Yes, my lord. But my lord, that's worded in a very I read, my lord, 372. No appeal shall lie from the judgment or order of a criminal court except as provided by this code or by any other law for the time being in force. Lord, Parliament is aware while framing DV Act that 372 doesn't allow the appeal as a matter of course. And therefore, my lord, conscious of that, the appeal is provided to the Sessions Court. They had to make a special provision under 29.
Yes.
So, my lord, this is consciousness. Now, my lord, having seen the 372, please have a look at 397. And this is also an issue which is recurringly arising before the courts, high courts, whether revision is maintainable under DV Act. Section 397. May I read? High Court or any sessions judge may call and examine the record of any proceeding before any inferior court situate within its or his local jurisdiction for the purpose of satisfying itself or himself as to the correctness, legality or propriety of any finding, sentence or order recorded or passed, and as to the regularity of any proceeding of such inferior court, and may, when calling for such record, direct that the execution of any sentence or order be suspended, or if the accused is in confinement, that he be released on bail or on his own bond, pending the examination of the record, and then explanation all magistrate, whether executive, judicial, and whether exercising original or appellate jurisdiction shall be deemed to be inferior. So, my lord, the question which is before Allahabad High Court, a question arose and it was referred to 3 judges bench. They have taken the view that 397 is available. But, my lord, the moment you say that 482 is not available, my lord, even the maintainability of revision under 397 will be questionable. So also, my lord, question will arise whether transfer petitions will lie to the
any case
or
answerable right in under section 28(1).
Yes.
Proceeding under section 12, provisions of CRPC are applicable.
But Madras High Court says not applicable, should be governed by.
The difference between governed by and applicable.
That is analyzed by the Madras High Court. So, we are looking to the overall provisions of the DV Act made with the CRPC. So, there is no manner of doubt that police machinery is available. The coercive nature of power under the CRPC is available. It is the court which is constituted under the CRPC which is conferred with the power. And therefore, 482, my lord, is something which is inescapable. My lord, the High Court, our inherent jurisdiction cannot be, my lord, avoided. And my lord, there is also aspect of transfer petitions, my lord, whether it will go before the civil jurisdiction or in any case, section 24-25 cannot be available because CPC doesn't apply. So, my lord, there may be a problem for maintaining such petitions under the for transfer, my lord, under the DV Act. That is another aspect. My lord, having submitted, my lord, on the basis of this, on the second aspect that your Ashish, my lord, pointed out. May I just point out, my lord, in my case, what is the DV Act complaint, my lord? Just have a look at that. Section 482. Before I read the complaint, I will just point out one factual aspect. Lord, page 38 is the complaint.
Yes.
Lord, the wife, in the meanwhile, has, my lord, got the decree for divorce. She has remarried. So, well, this is the factual background your lordship may just keep in mind. And now, please have a look at section 38, page 38.
So, decree of divorce is subsequent to this. Subsequent, and thereafter,
she has married.
Nobody challenged that decree.
Yes, that has attained final letter. Page 38 shows the title. Pratik, my lord, is the husband, and Vivekanand and Meera are the father-in-law, mother-in-law, and Saurabh, my lord, is the brother-in-law who practices in Delhi. And my lord, this is a case from Uttar Pradesh, my lord, far away from Delhi. I will first show, my lord, what are the prayers, and then, my lord, take your lordships to the case which is advanced.
Because reliefs are claimed under which provision?
Yes, my lord. Please have a look at page 45. First is restraint order. Respondent be restrained from indulging into any act of, that is against husband specifically, for restraining from causing personal or bodily or mental harassment, then for residence according to section 19, that no any arrangement for residence of so and so has been made. As no arrangement for residence has been made, a sum of rupees 30,000 be ordered to be paid. For economic relief under section 20, sum of rupees 1 lakh per month be awarded. And then custody, this is something, my lord, custody doesn't arrive actually. There is no child, my lord, so I don't know how come this has come. And D, orders for.
This is actually copy paste.
Yes, my lord.
Copy paste for that player has come.
That shows, my lord, the manner in which the complaint is filed. Orders may kindly be passed for payment of 36 lakhs as compensation for mental, bodily pains, etc. Please have a look at, my lord, what is the case advanced in the complaint. Page 39.
This is for past period. This can be granted.
Lord, it was cruelty, it was ex parte. And that allegation is against the husband. So, my lord, for the present, I will not urge, my lord, even the V Act, my lord, although husband also is one of the petitioners before the High Court. I will show, my lord, insofar as the in-laws are concerned, the father, mother, and the brother, my lord, there is no case actually.
Because if finding of cruelty against the husband is there, then perhaps prayer D will survive.
Insofar as husband is concerned, what I am saying is today, my lord, I am advancing case essentially on behalf of the in-laws. And from that point of view, please have a look at the complaint. That marriage of the applicant agreed has been solemnized on 12/12/19 at Devas, according to Hindu rites. Father of the applicant had exchanged dowry according to his capacity, in which gold made bracelet, gold, etc., etc. This is the background of the marriage. Straight away come to para 2. After solemnization of marriage, applicant victim stayed with the respondent as wedded wife, and while discharging her duties as wife, applicant victim provided comfort of conjugation to respondent. But the behavior of the respondent, my lord, here she means husband, did not remain good towards applicant victim. After some time from marriage itself, respondent started raising demand of dowry from applicant by saying that you go and bring cash of rupees 20 lakhs and one SUV car. Otherwise, respondent used to refuse to keep applicant with him and used to harass applicant by subjecting the bodily beatings. He used to, so this is all referring to husband. He used to extend threat to give beatings on trifle things, used to use unparliamentary words, extend threat to eliminate parents of applicant, and used to subject applicant to bodily beatings. As such, applicant was advised several times to desist from his violent conduct, but no any improvement was experienced in his behavior. And mother Meera, father and brother so and so joined hands with the respondent and harassed so and so. This is the only statement, Millard, in the entire complaint, and all raised demand of dowry. After marriage, applicant stayed at Allahabad for 10 days. Just mark this. During the said period, respondent number 1 did not stay with the applicant victim and he remained in UK during that period. When the respondent number 1 stayed in UK, so she went to UK thereafter. We'll have to show that. Then applicant victim went in with the respondent, stayed there with the respondent for 15-20 days. Even then, the respondent started indulging in quarrel with the applicant victim and uttered that your father has given nothing in dowry. You go and bring car, otherwise you will be eliminated, and started using abusive words, subjecting to bodily beatings and harassing. He suspects on each and everything. During the period of serving the TCS company, the applicant had got promotion, and then respondent questioned applicant victim as to how has she got promotion. He does not know. Respondent used to indulge in character assassination of the applicant victim by laying allegations on the issue of if your lordship see, my lord, it is all about the husband. And my lord, the fact that she stayed in UK with him, she was working in South Africa also for some time.
Decree of divorce is placed on record?
No, my lord, that it is not on record.
Is it? Or it will ask the respondent whether it is admitted position. All right.
In the face of that, my lord, impleading us, and my lord, this is a kind of harassment, though it may not have same implications
for the other petitioners.
No, Lord, other petition they had said that it is settled, etc. They were to point out that it's not been settled. Lord, what has happened is from the complaint has been allowed. Also, it's against the husband williams. So he had handed over the order laws, the complaint has been allowed. Now the husband is being directed to between of 5,000 for the rent.
So you are in which case?
2.1.
2.1.
Like 2.1.
So that is not set. That is not settled.
Because the order has
Order is
per se law, this petition was papered by the laws,
Right.
not by the husband.
So therefore now the finally disposed of complaint is
Process has been finally disposed of.
all right. So this will not survive now.
No, but the only condition was that the judgment has been passed for the husband. The husband is not a petitioner here. Since in that case also below the law is formulated.
Complaint is disposed of as against the petitioners also.
Law is as against the husband.
So what happens to the petitioners?
Thus, there is no role otherwise attached.
No. What is the final order in the complaint?
No,
Such.
the final order is against the husband below that.
No. So therefore, is the complaint dismissed against the laws?
No, they were proceeded ex parte.
Ex parte.
Yes.
So there is some final order passed against the laws also.
No, the only that is against the husband.
So where is that order? Just place it on record. We'll dispose it of.
Plus, this was handed over on the last day.
Right. He wanted us to record that. Right.
Lord, there is only last submission. May I just make that, Lord? Lord, the judgments of the High Courts which take a view that 482 is not maintainable rely upon the judgment of this Honorable Court in 2016, Volume 11,
That is
777.
where it is said it is a civil proceeding.
No, there was a background. And actually,
Well, let us go to only that judgment of the
yes,
court.
Lord, please have the bedtime. May I just point out what the controversy
So
was?
let us go to that
An
judgment.
application for amendment of complaint was made. And
Correct.
there,
We are aware of that, but still show us that judgment.
yes. 2016, Volume
So,
11, page
What page
774.
number of your
Lord,
compilation?
page number is 774.
So your compilation.
Lord, it's in the compilation of the other side.
Compilation on this side. What is that page number? That will not change anything because
Lord, 133.
actually the issue was completely different. Paragraph 2.
Only about
Court
the
did not consider this going to the question whether 482 will apply.
Precisely.
Whether the court has power to allow amendment of the
Precisely.
complaint. That's all.
That's the only issue which was actually
That
arising, and
statement was
therefore
shortlisted.
those observations may not be relevant for our purposes.
Alright, who is appearing for respondent in the first one?
But last time he was, yes, he is there. Milord.
Is there? Yes. You are not audible. Mr. Tandon, you are not audible. What is the volume? I think he has some audio issue at his end. Alright, we'll call out at 2 o'clock. We'll finish it today. Just take down in 2.1. Learned counsel appearing for the petitioners has placed on record a copy of order dated 17 January 25, by which the complaint subject matter of the petition has been disposed of. Hence, nothing survives in the petition and the same is disposed of. Disposal of this petition will not preclude the petitioners from challenging the said order in accordance with law. We'll take it at 2 o'clock. It's an audio issue with Mr. Tandon.
I'm so sorry, Milord.
Yes, now all right, yes.
May I make my submission,
Now,
Milord?
yes, firstly on facts to tell us, is it correct that after section 12 complaint was filed, there is a decree of divorce?
Yes, Milord. There is an ex parte divorce. I had filed it and it is against the husband.
Right. So that decree has become final now.
Yes, Milord. I am not aware if the husband has challenged it.
And is it correct that the wife has remarried?
Yes, yes, Milord. I had made that submission on the last date as well. It's correct.
Correct. So that, okay, yes.
Now, Milord, I understand my lords have taken a view, prima facie view that the CRPC will be 482 will be applicable. It will apply, and that
you can confine your argument properly. Our prima facie view is it is a court before which complaint is maintainable. Now, court is court of judicial magistrate. Therefore, inherent power of the High Court cannot cannot be taken away under 482 because emphasis is on code, and that also last two parts of 482 will apply, not the first part.
Very well.
Last two parts. Now, but however, it is subject to rider that considering the beneficial nature of legislation and difference between complaint under section 12 and complaint under section 200, court should be very slow in interfering. For example, under section 12, there is no requirement of recording any prima facie finding. Court has to just fix a date and then notice will go.
Please.
So it's not on par with 200 that complainant is required to be examined and there has to be application of fine.
It's issuance
So
of notice versus issuance of summons.
It is automatic. In fact, it is automatic. Within 3 days, the court has to do that. Court has to fix a date. That's what specific provision is there. Under subsection 4, magistrate shall fix the first date of hearing, which shall not be ordinarily beyond 3 days from the date of receipt of the application.
Miloj, on this, I can speak from personal experience. There have been cases where there was a case filed by the daughter-in-law. I was appearing for the father-in-law. Instead of issuing notices to the sisters-in-law, the court on the first day itself dropped them. I can state from personal experience, this may be a one-off case, but it's not that the magistrates just blindly issue notice.
No,
There
we
is
did
some
not go thus far. We did not go thus far.
Please.
The order of issuing notice under section 12 complaint need not be treated on par with issuance of process under section 200.
Please.
Because the process issued under section 200, criminal law is set in motion, which has very drastic consequences.
Please.
So what are your submissions now?
Milord, firstly, the court of magistrate is a designated court, Milord. If my lord sees the applicability, there is no applicability of CRPC. The proceedings under the DV Act will be governed by the code, Milord. And wherever
What
CRPC has been...
No, we want to know from you what is the difference between. So, when the section says will be governed by provisions of CRPC,
Please.
so can you say that therefore CRPC will not apply?
No, Milord. I will not say CRPC will not apply. I am only saying, and what the Madras High Court has also said, I will draw sustenance from there, that applicability is much larger than being governed by. Well, applicability means the entire CRPC wholesale will apply. Here, my lords have seen, my lord senior took the court through various provisions, rules. In every instance where the CRPC is applicable, it has specifically been stated there. And Milord, even otherwise, the court of magistrate is a designated court under the Act. He is not hearing criminal proceedings. There is no offence. There is no sentence which can be imposed. He is hearing. There are no, as my lord rightly said, there are no summons issued. This is a notice. This is not equivalent to the situation in Adalat Prasad versus Ruplal Jindal. That's also been dealt with by the courts below, Milords. The nature of relief, I understand, is civil. I won't harp on that, Milords. And even as far as section 28 is concerned, the language, Milords, may only I'll just briefly read it. 28 says, save as otherwise provided in this Act. All proceedings under sections 12, 18, 19, 20, 21, 22 and 23 and offences under section 31. There is only one offence under the DV Act, which is 31, that comes in when there is a violation. And that if it is governed by the CRPC, then, Milords, for 31, yes, 482 will apply because, Milords, that is an order passed under the code. It's the same thing for 125 CRPC because that is also an order passed under the code, Milord. But otherwise, Milords, 482, in my respectful submission, would not be applicable because, Milords, the substance of the proceedings is civil. It is only the procedural law which is the Code of Criminal Procedure, Milords.
But just see again 482. 482 makes a distinction. 482 does not remain confined to order under this code. Please see that. 482 again.
Lord, it says, nothing in this code shall be deemed to limit or affect the inherent powers of the High Court to make such orders as may be necessary to give effect to any order under this code.
The code, then there is a comma.
Yes, Lord. Then there is a comma to prevent abuse of process
of any code. So therefore, latter part of 482 will apply in this case.
Lord,
because the abuse of process of any court. Now, any court will include the court of judicial magistrate.
I agree, Milord.
First part may not apply. First part may not apply. You are right there. First part may not apply. Ending with any order under the court, that may not apply. The latter part will apply.
My submission here would be, Milord, since the proceedings here are essentially civil in nature, Milord, it's only the criminal procedure which is here. Even as far as appeal is concerned, appeal goes to the Sessions Court in the absence of any rules being framed, especially governing the appeal process. The rules already in place for the Court of Session will govern the appeal proceedings as well, Milord. Therefore, it is only because of that vacuum that the CRPC proceedings and already existing process for the Court of Sessions would already apply in the absence of any rules being framed, especially for the appeals. And otherwise, also, Milords, there is power enough. The parties aggrieved by any order passed by the magistrate or a complaint can approach the magistrate in the first instance. This is not a summons which has been issued. Even after issuance of notice, if the court finds that there is an abuse.
There you may be right. I mean, Adalat Prasad will not apply here.
Yes, Milords. So my submission here is, Milords, if any party is aggrieved, for example, if far off relatives, somebody far removed from the actual married couple, the aggrieved person under the act has been made a party, the court can always scrutinize whatever is there and see whether there is actually anything made out. Yes, Milords, this is a beneficial legislation, and this court has held in a number of judgments where they've balanced the rights, be it under maintenance of parents and senior citizens act, Milords, as well as where there have been claims being made under DV for residential orders and when there are civil suits for eviction. Those judgments are there. Lords, I just state one more thing. As far as, may I continue?
Yes.
Lords,
Yes, please.
As
Yes.
far as DV Act is concerned, there's one judgment which I have also relied upon in my written submissions. That is Prabha Tyagi versus Kamlesh Devi. Lords, that is by this honorable court itself. It's at page 4. I have extracted the portions in my written submissions. Milord, the essence of the judgment states, and to some extent which may be applicable here, since my learned senior has stressed on the fact that the complaint does not deal with allegations against the in-laws, because she stayed with the in-laws, but what Prabha Tyagi versus Kamlesh Devi says is physical presence in the shared household may not be necessary for a person to be aggrieved of domestic violence against the in-laws. The relevant paragraphs I have extracted, it starts at page 4 towards the bottom. There's a running paragraph.
No, we just want to ask you a question.
Please.
Now, after decree of divorce is passed, she has remarried. We can understand for compensation, she can continue to press the complaint.
Please.
Because she wants to press it against in-laws also. Husband, yes, she can press it because there is a compensation paid for the earlier period. That is a matter of evidence.
When I had spoken with the client, Milords, my instructions are that all her jewelry and everything are with the respondents, Milords, are within the petitioners in this case. Her in-laws and husband, she is not aware who has it. And since that decree of divorce has been granted ex parte, there is no other way for her to get those back. So it's bleak that she'll get it. But if my lords want on a specific query, I can seek instructions, Milords.
All right. Yes, anything further you want to add?
No, Lord, I mostly covered whatever I had to say. As far as the test is concerned, Milords, there are 2-3 points, Milords, which I may just state.
Yes.
Apart from the immediate family, which means maybe the husband, father-in-law, mother-in-law, maybe a brother-in-law, the court should scrutinize the role of the other persons arrayed as accused to see if there is anything made out. Milords, more than perhaps a cursory glance over the complaint, just to see that if there is anything of substance against the other accused persons. Milords, the allegations against each person to some extent must be set out in the complaint. And whether proceedings are taking from 482, where they are vexatious, prima facie, or seem to be an abuse of process, the party should be deleted, either by the magistrate himself or on an application.
No, that actually, after notice is issued, naturally, in-laws, political in-laws, they will appear. At that stage, they can always point out that there is no material against them.
Very well.
At that stage, in-laws can always point out.
Very well.
Therefore, we are trying to distinguish it between 200 CRPC and 12. Under 12, respondent can appear and say that there is no role ascribed to me.
Yes, Milords.
And application should not be entertained, or residence order should not be passed against me.
Yes.
That argument is always open.
The distinction I've also stated in my written submissions. That's there, Milords.
Correct.
Because then my first suggestion here, I'm sorry.
Yes.
Because here then I'll come back to my first submission, which is apart from the immediate family, if there are others who have been arrayed as accused respondents, that may be looked into by the magistrate.
All right. All right. Okay. All right. Submissions are heard.
It's arising out of FIR. Your lordships have said that after we conclude this, we'll fix it.
Correct, but this will have to be independently decided.
I know. Therefore, your lordship fix that matter, my lord, arising out of FIR.
That first judgment will pronounce and then
Very well.
So grateful, my lords.
Please.